Yes, English steno dictation. The sad version of Choti PW1 was fully corroborated by PW3 and 15, who are none other than the children of the deceased, and Choti PW1 stopped in fact at the time of occurrence. Kumari Sarita PW3 was 7.5 years old, and Vikram PW15 was 1.5 years younger than Kumari Sarita PW3 stop. Further, in the orientation of the witnesses, the trial court has found that they were fully conscious of what they were to state before the court, and their answers to the questions did disclose that they were able to understand the whole purpose of giving their evidence in court, and as to on what matter they were supposed to give their evidence. Stop. Even while narrating the incident, both the above witnesses were able to fully support the version of Choti PW1 as regards the involvement of each one of the accused, the weapons used by them in that process, and the ultimate death of the deceased after such severe beating with the weapons used. Stop. Next, the learned counsel of the respondents accused, while making reference to the version of Kumari Sarita PW3 in the cross examination, that on the date of occurrence at about 9 to 9:13 p.m. they went to sleep, and submitted that the evidence of the said eyewitness cannot be relied upon. Stop. We see no good reason to accept that said submission, in as much as in our considered opinion, considering the extent of statement made by the said witness as regards the incident in a graphic manner, the said stray statement about their going to sleep by 9 to 9:13 p.m. was an insignificant one, and on that basis it will be wholly inappropriate to disbelieve the version of Kumari Sarita PW3, whose version in all other respects was natural and fully supported the eyewitness account of Choti PW1. Stop. Next. Similarly, we find absolutely no discrepancy in the version of Vikram PW15 was even younger than Kumari Sarita PW3 in age at the time of the occurrence, but yet his version before the court, as recorded by the trial court, disclosed that he was only speaking the truth, and he was able to give the required details as regards the manner in which the occurrence took place, the involvement of the respondents accused, and the weapons which they used in the that process and the ultimate killing of his father at the instance of the respondents accused Stowe. Next, in this context, it is relevant to rely on a decision of this court reported in state of Madhya Pradesh versus Ramesh and another 2011 page 4 SCC 786 wherein it laid down as to how the evidence of a child witness should be assessed. Stop. Paragraph 7, 11 and 14 which are relevant for our purpose are as under. Next, in Rameswar versus State of Rajasthan, this court examined the provisions of Section 5 of the Oaths Act 1873 and Section 118 of the Evidence Act 1872 and held that AIR page 55 para 7 every witness in competent to depose unless the court considers that he is prevented from understanding the question put to him or from giving rational answers by reason of tender age, extreme old age, disease, whether of body or mind, or any other cause of the same kind. Stop. There is always competency in fact unless the court considers otherwise. Stop. The court further held as under AIR page 56 para 11 stop para. It is desirable that judges and magistrates should always record their opinion that the child understands the duty of speaking the truth and state where why they think that otherwise the credibility of the witness may be seriously affected, so much so that in some cases it may be necessary to reject the evidence altogether. Stop. But whether the magistrate or judge really was of that opinion can. Stop.